You have crossed the line between free speech and defamation of character. You have crossed the line. Malicious intent is where it is. And if you keep going, you will lose everything. You have also no way have we ever given you permission to post my photos. I will sue you if you don't take those photos down immediately.
All right, we're on track number 1.
Welcome to the conferencing center. At any time during this message, please... If you need technical assistance during your call, press *0. There are 8 parties in conference, including you.
This is a specially set 341 meeting at 1:30 on Wednesday, November 29th, 2023. 341 meeting being conducted by Devin Durham Burke, the Chapter 13 trustee. We're conducting the meeting by telephone, and this is for the purpose of, it's a continued 341 meeting in the matter of Kenneth and Valerie Jenvey, case number 2350878. And we're on track number 1. Are the debtors present? Mr. and Mrs. Jenvey, are you on the line?
Yes.
Okay, Mr. Jenvey, are you also on the line?
Yes.
Okay, can you each please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give this afternoon is the truth, whole truth, and nothing but the truth?
Yes.
Please state your names for the record.
Valerie.
All right, Mr. Jenvey?
Kenneth Jenvey.
Thank you.
Kenneth Jenvey.
All right, thank you. And I am looking at images of a California driver's license for Mr. Jenvey and a United States passport card for Ms. Jenvey for the photo ID. And for Social Security proof, I am looking at images of your Social Security cards that have numbers on them that match the numbers in the bankruptcy petition. This question is for each of you. Are you the individual whose name and address appears on the voluntary bankruptcy petition as the debtor?
Yes.
Yes.
Thank you. And Mr. Gunther, please make your appearance.
Ralph Gunther appearing on behalf of Mr. and Mrs. Jenvey. I can confirm I reviewed a driver's license for Mr. Jenvey, a passport card for Mr. and Social Security cards for each. Information matches that found in the notice and petition.
Thank you. With that, identity is verified. You are current through October with your plan payments. Looks like we need a plan payment for November, which was due on the 20th. So please make sure you get that in on...
That should have been received.
Okay. This... okay, let me say, hang on one second. We do have it, actually. Okay, we've got $5,400 on hand, and that brings them current through November. So your next plan payment is due by December 20th and the 20th of the month thereafter. And the address on the bankruptcy petition is your current address still, correct?
Yes.
Correct.
Okay. All right, so I'm not going to repeat all the questions that I had before, but I do have a couple of questions that I want to ask before I allow creditors time for questioning. And the main purpose for holding this second meeting is to give creditors an opportunity to ask questions. The first meeting we had went very, very long, and creditors didn't have adequate time. But I do want to set, let me find out, first of all, how many creditors are on the line right now? Can you just...
I'm here.
And tell me your name?
Katie Diego.
Okay, and who else do we have?
Rebecca Lomeli.
Okay, and who else do we have?
Crowd Pleaser Frenchies LLC with Heather McPherson, owner.
Okay, and who else do we have?
Kathy Moran.
Okay, and who else do we have? Anyone? Okay, so Ms. Moran, you are representing all three of the individual creditors that stated their names. Are you going to be asking questions for them, or are they going to ask questions, themselves?
My representation of any of the creditors beyond crowd pleasers was a standalone representation, given the short period of time you provided for filing objections. I have questions. I believe that my client has a different line of questions as well.
Okay. All right. I'm just trying to get a sense of how much time to allot for everyone. My goal was to have this meeting last no more than about an hour, and I don't have very many questions, so it's mainly creditors being given a chance to ask questions. And just want to remind the non-attorney creditors that the purpose of this meeting really is to just ask questions about the debtor's assets, debts, and to get factual information. Ask about information in the paperwork. This is not the forum or the right place to be asking things like rhetorical questions or making position statements or arguing with the debtors or making any kind of legal arguments. I'm not a judge, I'm the trustee, and my purpose is really just to conduct a meeting to get facts and information. So I want to just remind everyone about that. I don't want this to devolve into some kind of a free-for-all, or I'll just conclude the meeting. Oh, yeah, I did get Mr. Gunther's. No, yeah, I did. I'll get it again, though. All right, so, and just wanted to let everyone know that if the time that I'm allotting today is not enough, you always have the opportunity to schedule a 2004 exam, and that way you'll have a lot longer time to ask questions. Mr. Gunther, I apologize. Did I not get your appearance?
You did get my appearance, so I'm happy to appear again.
Okay, that's okay. That's all right. I'm on a recording device, so I'm sure that we got it, if you say we did. Okay, so let me just start by asking the questions that I have. The first one I have for the debtors is, what is the status of filing your 2022 federal and state tax returns? Where are you on that?
22 has been filed.
Okay, has that been sent over to me, Mr. Gunther? Because I didn't have it in my
I have done
documents.
the 2022 return yet.
I'm sorry, say that again, you were cutting out.
I have not received a copy of the 2022 return yet.
Okay, so Mr. Jenvey, when do you plan to send the 2022 state and federal returns and W-2 over to Mr. Gunther?
I can do that at any time.
So I would suggest that you do it as soon as possible. And also, just as a reminder, I think Ms. Moran has an outstanding request for the same documents. So Mr. Gunther can take care of that. Then, Mr. Jenvey, I've got a question about a post-petition pay stub that you provided to me that has some retroactive pay on it that I just had a question about. This was a pay stub, I think that for pay period, the pay date on this pay stub is August 18th, 2023, and this case was filed on August 11th, 2023. This pay stub has retroactive earnings on it in the amount of $35,628. So my question for you is, what is this retroactive earnings pay? What's it for?
So there was my categorization at work received a pay increase that was effective January of 2023. But it's the federal government. For whatever reason, it wasn't included in our pay until that date. And so anything prior to that date was given as a one-time lump sum.
Okay. And going forward, after this pay stub that you received for pay date 8/18, your paychecks reflected the increase after that?
Correct.
Okay. Making some notes here. All right. And then on your budget, in addition to budgeting, you have medical insurance coming out of your pay stub, but you're also on your budgeting $500 a month for out-of-pocket medical expenses. So is that an accurate amount in terms of what you spend on average every month for out-of-pocket medical?
Well, I'm just beginning a series of deferred dental work. We're still in the progress of putting the plan together, so that was an estimate at the time of filing. It should be close to accurate.
Okay.
We can adjust if needed.
Do you know what the total amount will be for the dental work? Because you're going to be in this case.
I don't at this point. We're still. I'm sorry?
You're going to be. You're in this case for about 5 years. So $30,000 worth of dental work. Is that what it's going to cost? Do you know?
Potentially. And we're still trying to work with insurance to see what's covered and what's not going to be covered.
Is anything else being paid for with that out-of-pocket expense, or is it just dental work?
Well, we have co-pays if we have other medical. I mean, I do an annual physical, which has a co-pay, as does my wife.
Okay.
And then anytime we go to see the doctor, we have a co-pay.
All right.
There's minimal prescription medication as well.
Okay. Switching gears, this question is for each of you. Not including, the last time we were on this call, you disclosed that you did have counterclaims filed against parties that were suing you in Monterey State Court before this case was filed. They weren't the counterclaims that you filed against the plaintiffs were not disclosed in this paperwork, and I've objected to get an amendment to disclose that. But apart from those counterclaims in those lawsuits, do either of you have any claims against anyone, whether they're filed or not, for anything like unpaid contract amounts, fees due to you, or any other damages? Do you have any claims against anyone for this type of thing?
There are some outstanding. Go ahead.
Just a second. Madam Trustee, let me respond to that initially. I have discussed with my clients, they have various defamation or slander claims against individuals who are creditors in this case, and I know that they have done some investigation with respect to that, and frankly, it's an open question as to whether or not they have the ability to pursue those claims or not. So that would be a separate claim apart from the counterclaims that were discussed at the prior meeting. And Mr. Jenvey can probably provide more background on that if it's necessary. But my understanding in my conversations with my clients was that they, to the extent that that was all pre-petition, the bankruptcy was going to prevent them from having the ability to pursue those claims. And so we, as a result, we did not list that as an asset of the estate.
All right. Thank you for that information, Mr. Gunther. So for the debtors, Mr. Gunther is not testifying because he's not a debtor. But you heard what he just said. Was his rendition of the facts accurate?
Yes.
Mr. Jenvey?
Yes, and I will add there are unfulfilled contractual obligations. Uh-oh.
Okay, concerning what? Sales of dogs? Mr. Jenvey, are you still there?
Oh, I'm sorry, I got disconnected for a moment. I think I'm back. Am I back?
Oh, yeah, I can hear you. All right.
Okay. There are some unfulfilled contractual obligations, primarily around dog sales. And in discussions with Mr. Gunther, it is yet to be determined whether we will pursue any of those. At the time of filing, it was felt that we probably would not be pursuing any of those, and therefore they were not included.
Have you, at the time of filing or since filing, have you filed any kind of lawsuits for defamation, slander, anything like that?
No.
All right. So I do need to track what happens with your decision about this, because the fact that you may not be able to or may choose not to pursue these claims doesn't mean they should not be disclosed, because they are pre-petition claims, it sounds like, and the only thing for you to decide is whether you're going to be doing anything about it while you're in the Chapter 13 case, whether you can afford to or whether you want to, that sort of thing. So I do need to have these claims, and they are just, sounds like they're just that. You haven't filed any kind of litigation, but these claims do need to be listed on the asset schedule. The defamation / slander claims were they only against creditors creditors that are involved in your bankruptcy, or were there others that are not creditors necessarily?
Others. There are others.
Okay, so I want a listing of who the possible defendants might be for the defamation or slander or other damages type claims that you have against people. So Schedule A needs to itemize. I don't want just some generic, broad description, slander claims against various people or something like that. I want to know who they are and what your possible claim is against them. And if you can ascribe a dollar amount to it, fine. If you can't, I'll let Mr. Gunther decide what to do. I'm going to track this also, so I want Schedule A be amended to list them and place a value on them. And then I also want a non-standard provision added to the plan that will provide status reports to me on a periodic basis that are filed that describe what's going on with any of these claims. And we'll give you language, Mr. Gunther, about that, and we'll have the first one of these status reports be due, why don't we say July 1st, 2024. And for the assistant who's here with me taking notes, I want the file back so that I can outline for the analyst the things that I want to be described in the status reports. And I want them filed so that the creditors can look on the docket and see what you're telling me every 6 months about the status of these claims, okay? All right, and that's it for my questions. So why don't we start with Ms. Diego. What questions do you have for the debtors?
I was just wondering what their relationship was with Jennifer Ivey.
Spell the last name of the person, Jennifer who?
Ivey, I-V-E-Y.
Okay.
Ms. Diego, who is Jennifer?
That's why I'm asking the Jenveys what their relationship is with her. Like in a business sense or a friend sense?
I don't know how to respond. I don't know how I can ask them to respond to that question. Who is Jennifer Ivey?
Yes, who is she to them? Is she a business partner to them with their dog? Is she a guardian home, like co-owned? That's my question. In the business, who is she to them?
I can answer that so easily. She owns studs that we use. That's it.
So then, does she do you co-own too, or is it like a partner, or you just do studs from her? That's it.
We purchase semen from studs that she owns.
Gotcha. Okay, thank you. That was it. And then do they purchase from you?
We sold them a dog, yes.
Okay, that was all the questions I have today, honestly.
All right, thank you. How about Ms. Lamelli? What questions do you have for the debtors?
Hi there. Do you have a judgment against Mindy Hazel Sanchez, and for how much?
Yes. I believe the amount is $12,000.
Was that included in the list of judgments that you filed in the petition?
No, at this point there's no hope of collecting anything on that, so I did not include it.
Okay, I'm asking that because I would imagine that it would supposed to have been listed in the judgments that could have been tracked as potential assets. That's all I wanted to ask. Thank you.
All right, so following up on that, I want the asset schedule amended to list the judgment against Mindy Hazel Sanchez. That needs to be disclosed. So, Mr. and Mrs. Jenvey, just because, in your opinion, you think things aren't going to end up being collectible, does not mean that they should not be disclosed. So, if you've got other things out there that in your judgment you decided not to include because you didn't think it was going to be worth anything, you should get with Mr. Gunther and fully disclose all of this, because when things like judgments are not disclosed, that is a serious matter in a bankruptcy filing, because you're supposed to disclose everything, and you're signing these papers under penalty of perjury, basically indicating that everything in there is true and correct. So the questions are not whether or not something's collectible. The question is, do you have a judgment? Is there a judgment that you have that's out there? Just please be aware of that, because omitted assets or underreporting of income is a bankruptcy crime. And it's something that everyone takes really seriously. And from last time's, the testimony at the last meeting, what I came away with was a whole list of things that, through questioning by me and by others, I learned that a lot of things were omitted in your schedules, and so that does not bode well for you. So just warning you about that. Okay. All right. So Ms. Lamelli,
I will review that. I think we're beyond the statute on that being a collectible item, but I will review it. It's several years old.
Ms. Lamelli?
I will review it with Mr. Gunther.
All right. Ms. Lamelli, that was it for your questions?
I'd also like to know if they've made a decision if they're going to declare Al Capone as an asset in this case or not.
We do not have possession of Al Capone. We have no ability to make money with him. He is not an asset.
He's not an asset. So you're saying he's worth nothing?
Do you intend to pay us anything for him?
No, So
He is not in our possession. He is not in our possession. We have no control. We don't have the ability to sell the dog. We don't have the ability to market the dog. The dog is not an asset to us. He is of no value to us at this point. He is not in our possession.
Okay, that's good to know because I am the custodial owner per the contract you gave me. And also, I do have a case in Monterey County, Oakland against you.
Ms. Lamelli, do you have any?
Go ahead, Mr.
I'm sorry, can I finish, please?
All right.
Do you have any questions?
I am the custodial owner per the contract, and I do have a case.
All right, let's let.
Can I finish, please?
We need to let Ms. Lamelli finish, and then Mr. Gunther, if you've got something you want to clarify, that's fine. Also, if the debtors have something, that's fine. I need to create a record that doesn't include a lot of people talking over each other. Otherwise, this record means nothing. So, Ms. Lamelli, please finish.
Okay, I was asking because I do have an open case, and that would be something that would need to be listed as a potential asset. So they're saying Al Capone is worth nothing. I'm the custodial owner per the contract, so it wouldn't have mattered if they ever had custody of him or not. So thank you for letting me know that you have stated he is worth nothing.
Ms. Lamelli,
In your opinion. Okay.
Ms. Lamelli, you said you have an open case. What does that mean?
Yes, I have a case in Monterey County. I am suing the Jenveys for a full refund because they sold me the dog and they listed the incorrect father on the registration. And they're countersuing me. I'm suing them for $5,000, and they are countersuing me for $7,200.
Okay.
Which they did not list that suit.
Right.
And they also did not list this dog as an asset.
Okay. I do have, I am aware of that litigation, and they are going to be, I've already objected to have them amend their paperwork to show that counterclaim. All right.
Okay,
So,
very good. I was just wondering if there's been any status update on that.
Well, I'm imagining that the lawsuit that you brought against them has been stopped because of the bankruptcy. And if they want to proceed against you, then they're going to have to disclose that, I would think. They didn't disclose anything about this originally, but now the counterclaim is going to be disclosed as an asset. And so let me just ask the debtors, are you planning on pursuing your counterclaim against Ms. Lamelli? Mr. and Mrs. Jenvey, are you there?
This is in the category that we discussed earlier, that with our attorney we will determine whether to proceed on any of these or not.
Okay, well, I think what we were talking about earlier actually was not the counterclaims in the two Monterey County small claims actions. We were talking about counterclaims for defamation, slander, things that have not even been filed yet. So I guess I'll just ask you, since you need to speak with Mr. Gunther about how you intend to proceed, I'll just ask for a declaration under penalty of perjury that explains whether or not you intend to pursue the counterclaims that you have pending in Monterey County, the two small claims court actions. The one that was brought by Ms. Lamelli, and then I think the other one was brought by Crowd Pleaser Frenchies, LLC. So we'll ask for a declaration. You can explain in there what you intend to do. All right, I'm going to move on.
And
Who is
what
that?
you said is correct. The case has stayed right now. Thank you very much.
All right. All right. Let me move on to Ms. McPherson. Do you have questions for the debtors?
Yes, but I think I'm going to let Kathy Moran go first, and then I'll finish up behind her, if that's okay.
It's fine with me. Go ahead, Ms. Moran. Ms. Moran, are you there? Is anyone there, or did the line go? Okay.
I'm muted,
That's
or
fine.
I
That's okay.
was muted. Mr. and Mrs. Jenvey, I'm Kathy Moran. I'm an attorney. I represent Crowd Pleasers Frenchies, Inc. At the previous version of this 341 meeting, you agreed to provide a list of the names of the dogs that are scheduled in the assets, and I have yet to receive that. When can I expect it?
We're working on providing everything that was discussed at the last meeting to our attorney. There were several items that are all a work in progress.
Might I ask that you not wait till you've got all of your amendments in line and provide that sooner?
Ms. Moran, I'm happy to provide that as the information comes in to me, and there will be no delay in getting that information out to you.
Thank you. On your schedules, you listed a claim for the California sales taxes in the amount of $29,953. Where did that number come from?
From our filings with the Tax Assessing Authority.
And have you filed sales tax, all the sales tax returns required up to the point that your case was filed?
Yes.
And who prepares those sales tax returns?
I do.
And what records do you look at to file those returns?
Our litter registrations and our sales contracts.
Okay, I did some rough math using the sales tax rate for Monterey County, and I come up with gross sales behind that tax number in the order of $330,000. Is that a true reflection of the business operations of your dog breeding business?
That number seems high to me, but this goes back to 2017.
Okay, and has your business, well, what's been the trend of your dog breeding business from 2017 to the present? Has it grown or shrunken, stayed the same?
Up, down. Since we've been attacked on social media, our sales have been low.
Okay, let's talk about sales. I believe at the previous meeting you said you were anticipating 3 litters post filing. Have any of those litters been born?
We have a litter of 1. We have a litter home.
Excuse me, could you repeat that?
We do have one litter at home, yes. It was born last week.
And that's at your home?
Not at our home, it's with a partner, but that litter has now come home from the vet.
Okay, and who is the co-owner?
We prefer, it's not a co-own, it's a whelper, and we prefer not to give that information in an open forum.
Do you have an interest in the puppies in that litter?
Yes.
Yes.
We're the full owners. We are the full owners of that litter.
And how many pups in the litter?
11, although one will probably be surrendered. It has a defect.
Actually, 2. There's another one with a defect. The veterinarian nicked the head. So.
And when were these puppies born?
Wednesday before Thanksgiving, last week.
And the name of the mother?
Azariah.
I think I saw pictures of this litter on your Facebook page. Who is the sire of this litter? Could you repeat that?
O-Z-Z-Y, Ozzy the Wizard.
And do you have an interest in Ozzy the Wizard?
No.
No. We purchased semen.
Okay. So, at the last hearing, you testified that you were no longer able to conduct your dog breeding business from home, and that you now operate through co-owners and partners. I believe you... Or what?
Or whelpers.
And could you describe what a whelper is?
Somebody who's hired to whelp a litter of puppies.
Okay. And what is the fee for being a whelper?
Traditionally about $800 a week.
It's $800 to $1,200 a week, depending on the whelper. The lowest would be $800. The highest would be $1,200.
Okay. I noticed on your projected income and expense statement in Schedules I and J that you filed under penalty of perjury, you estimated your business expenses for the dog breeding business at $500 a month for food and vet bills. That seems inconsistent with the expense you just described for a whelper to care for this litter you own.
Well, that does not include breeding expenses. So stud fees, C-sections, those are specific to a litter, so they're not an ongoing monthly expense. So they'll show in the P&L statement.
But it certainly does influence whether your business is profitable. You listed your gross income for dog breeding for $1,000 a month. Do you recall that?
And that's in retrospect. After our last meeting, Mr. Gunther and I discussed that's probably more reflective of a net, not a gross.
Okay. Can we expect amended schedules that reflect that?
Yes.
It seems that the purpose of these schedules is to show on a monthly basis what your business operations look like, and the fact that an expense isn't every month doesn't justify excluding it from this discussion. Am I correct that you have 2 bitches yet to whelp?
Yes.
Yes.
And what are their names?
Majesty and Sequin.
Okay. And are you the full owner of each of those dogs?
Yes.
And who has custody of them?
Again, that's information I don't want to disclose in an open forum.
And why is that?
Because because there's people on this call that will seek these people out and call them and harass them, and I don't want to put those people through that. It's not fair.
Are you, do you incur an expense for a whelper prior to the litter being born?
No, usually there's a payment at the time the litter is delivered to the whelper.
Yeah, to start.
The litter is developed. I thought the purpose of the whelper was to care for the bitch through whelping.
Okay, we seem to have a confusion in terminology. So French Bulldogs are typically born by C-section at a veterinarian. So that's birth. Whelping is the raising of the puppies after birth.
Oh, my father was a veterinarian, and I would tell you that his understanding of whelping is different.
Okay, well, French Bulldogs are typically not born naturally. Your client should be able to tell you that. So the whelpers do not deliver the babies. They're delivered via C-section. So that's not a whelping, that's not an expense of the whelper, that's a veterinarian expense.
And then the figure, the monthly or the weekly figure you provided earlier is for the care of the puppies post-delivery.
Correct.
Okay. And so what's the expense associated with the C-section for, is it azuria?
Approximately $1,300. Approximately $1,300.
Okay. And it's your testimony that you are the full owner of Majesty and Sequin.
Yes.
Okay. You at the previous hearing, you indicated that you had partners, and the only one that I noted that you identified by name is Michael Young. Who else are your partners in the dog breeding business?
Again, information I'm not willing to disclose in an open forum.
I'm sorry, but that's information that should be disclosed in the bankruptcy schedules.
We can provide information to the trustee.
Well, the problem with that is
it will form the.
Go ahead, miss. Go ahead. Go ahead.
I think it'll form the basis of an expanded objection to confirmation, because how can creditors assess the fairness of your plan or its compliance with law if you don't disclose all the information associated with your business operations?
I think, and I think, Ms. Moran, I think I've also asked for disclosure of all the partners, because you are correct. In order for me to evaluate, I'm also doing a full-blown business examination. We've given the documents to Mr. Gunther, and so we do need to receive the business exam. Information that the debtors provide is not filed with the court. It's just provided to me. But I agree that in order to have enough information to evaluate the value of the assets at the time of filing and post-petition, we need to know who the partners are. So I've asked. I think I've asked for that, and if I haven't, I will ask for the names, and I'll go back and look at my business exam documents to make sure that the names of any partners.
Okay.
Yeah.
Madam Trust, this is Ralph Gunther. We have my clients have no qualms about providing that information to you. They do, for the reasons that were addressed on the record today, have an issue with that information being provided to these individuals who are on the line today. And if it's necessary, we can seek a protective order from the court with respect to these disclosures. And again, we're more than happy to do that if it becomes necessary. But my clients don't have any issue with providing this information to you as the trustee to allow you to conduct your investigation as needed.
All right, thank you.
You further testified that you had a number of dogs in which you had co-ownership. Is it your intention to list the dogs that you co-own when you amend the schedules?
Yes.
And what kind of records do you keep for the co-ownership situations?
We keep a spreadsheet of income and expenses per partner.
And is it? Well, I was asking about co-owners. Do you regard those as partners?
I'm not sure what the difference would be. A partner is somebody that we have a cooperative ownership agreement with.
And how many partners do you have?
Well, active partners, only one or two.
And does that
some of your clients could be considered partners, but there's no active partnership.
Well, I'm trying to determine, on the date you filed your bankruptcy petition, how many partners did you have?
I will review that with my attorney.
Would that be reflected in the records you keep?
Not understanding your question.
Do you have written records or electronic records that identify each of your partners?
When we have activity that involves a partner, we track income and expenses per partner, per co-owner, per whatever person that is.
And do you provide that that accounting to the partner?
Yes.
Okay. And does the partnership file tax returns?
It's not a formal partnership, so no.
And do you report
it's not a business entity.
I don't think it's necessary to be a separate entity to be a business or a profit-making undertaking. And you're going to list the co-owners in your amended schedules. Is that correct?
Yes.
Not for them to see. Only to the...
Are we changing the answer to my question? My notes indicate that you previously indicated that you would include the list of your co-owners in your amended schedules. Is that correct?
Ms. Moran, I'll respond to that, and we're going to discuss that the dogs that there is some type of co-ownership of will be identified. The percentage owned by the Jenveys will be identified, and to the extent someone else has an ownership interest, that percentage will also be identified. And at this stage, in terms of the schedules, it's my intent on behalf of Mr. and Mrs. Jenvey to provide that information, but not to provide the identity of the other individual that has an ownership interest in the dog.
Okay. And might I ask that the schedules be explicit about whether the value that you reflect on the schedule is the value of the debtor's ownership or the value of the dog as a whole?
Understood.
It was not clear on your existing schedules.
Yeah, I get it. I understand that. So the value of the dog should be presented, and then the debtor's interest in that should be indicated as well.
Very good. Okay, I want to talk about the social media presence for your dog breeding operation. What accounts on social media do you use to promote your business?
Bulldogs by the Sea, Frenchies of the Sea. That's it.
And do you have social media accounts for Seafoam Kennels?
Nope.
And which
Not anymore.
We used to. We don't have.
And when did you cease using Seafoam Kennels on social media?
I don't know, months ago.
And what platform was that on?
Probably Facebook.
And the two names that you gave me were Bulldogs by the Sea and Frenchies by the Sea. Is that correct?
Uh-huh.
And does anyone manage those social media accounts besides yourselves?
No.
And I've noticed that there are frequently pictures and video. I didn't see. Do you take the pictures that you post there?
Did I what?
Do you take? Are you the photographer for the images that are on the social media? I didn't see a camera scheduled.
Camera?
Do you have a camera?
I use my phone. I don't have a camera. I use my phone.
Okay. Have you made any sales of dogs since the petition was filed?
Yes.
And can you name the dogs and the price you received?
We're giving copies of our purchase agreements to our attorney and to the trustee for the discussion at the last meeting.
How many dogs did you sell?
6.
And were these all puppies?
Yes.
And have you priced the current litter?
No.
Is progesterone testing a service that you offer through your business?
No.
No.
Just personal.
And do you have equipment to conduct progesterone testing?
Yes.
We have recently purchased a progesterone testing unit, yes.
And what does that cost?
I don't remember exactly, $2,000? Valerie, do you remember specifically?
I know, around there, yeah. It might have been a little bit more, but not under.
If I understand, I'm now talking about Mr. Jenvey's salary, and you indicated to the trustee that your pay rate has been corrected to reflect a raise you got or should have gotten as of January 2023. So what is your current monthly gross income?
I would prefer to review that with my attorney before disclosing anything else. I have given copies of current pay stubs to the trustee.
Okay, but it strikes me that your increase in salary impacts your ability to fund the plan. And in the absence of an amendment that reflects that correctly, I will add that to my objection to confirmation.
Ms. Moran, based on the math calculations that my office did, we are objecting to have Schedule I and the means test schedules amended to show, we're showing that the current income monthly gross for him with the raise is $16,887.87, up from $12,823.84. That's what our thinking is regarding his increased salary, and we are objecting to have everything amended to reflect that.
Okay, very good. I think I will cede the remaining time to my client.
Okay, thank you. All right, Ms. McPherson, what questions do you have?
I'm a little confused as to why so much of this is there's a hesitance to disclose things that are already on social media as public posts.
So let me stop you right there. Can I stop you right there? So please, what you need to be focusing on is questions and not commentary or your interpretation or some kind of an argument. So if you have a question about what they're posting on social media, please phrase it in the form of a question. Okay?
Sure. Okay. So let's get started with, during the last 341 meeting, we were discussing rental income, and the testimony, as I understood it, was that there was only one person that has rented. So I'd like to ask, who is Corey Lester?
Corey Lester rented it from us a few years back, like maybe 3 years ago. He is no longer.
And how much was Corey Lester paying per month?
$750.
And can you please state the year that stopped?
We would have to go back and look. He was a naval officer at the Navy Postgraduate School. We rented a room to him, similar to the person we discussed last week.
Right. Because I'm showing that there are receipts from June, July, and August of 2020. Is that correct?
That's correct. That's probably right.
Possibly. Where do you have these receipts from?
They're in the subpoenaed documents from our court case that you're aware of because you were served the petition for subpoena. But back to you. I'm also showing receipts for $14,358.40 received from Lin Zhang. Can you confirm if that is correct?
Sounds pretty high.
So again, I would have to go back and review my records. The trustee has asked me to provide Venmo records, which sounds like where you're getting this information. You're accessing my Venmo account.
Well, I'm accessing subpoenaed documents. I'm showing $800 a month received for August through September. Actually, this is for 2021 and 2022. So So for 2021, it's showing $5,850, and for 2022, it's showing $8,508.40. Does that sound accurate?
Yeah.
I would have to review the numbers.
So did Lin Zhang rent from you in 2021?
Yeah.
Yes.
And how many months did he rent from you in 2021?
I would have to go back and look at when we rented to him and when he moved out. I don't have that information off the top of my head.
You also testified that you would be providing the rental contracts for that. So would that information show in those rental contracts?
It would show the rental start date. I'd have to review when, usually it's a verbal 30-day when they leave.
Okay. So did you rent to Lin Zhang in 2022?
Potentially. Again, I would have to go back and review the dates.
So this rental was for a room in your home, right? Your primary residence?
Correct.
So 2022 was last year. You can't recall if somebody was in your home?
Ms. McPherson, Mr. Jenvey answered your question.
No, he didn't answer that question.
He said he would have to review the records to confirm exactly the dates that the tenant was there.
Okay.
And Ms. McPherson, this is the trustee. I've objected to get a declaration from the debtors filed with the court under penalty of perjury disclosing rental income that they've received for calendar years 2021, 2022, and 2023, and rental agreements.
Okay.
So, you can look for that. Okay.
Okay. Well, if they're not planning to disclose that to their creditors, such as me, it's going to be difficult to get that information.
You can look on the court's, you can look on the court's docket. This is something that I'm requesting that they put into a written format under penalty of perjury and file it in this case. So you can look on the docket after this gets filed and review the information that they've provided.
Fantastic, thank you. I do have a question about guardian homes. In the 341 meeting on 11/15, there were several references to guardians, and I would just like to ask the Jenveys, what is their definition of a guardian home?
A home where a dog is placed there without being sold. So no longer in our physical possession.
But do you still own the dog that is in a guardian home?
Yes.
Do you own? All right. So the difference between an owner and a guardian home is typically what you just described. I'm still confused about the difference between a co-owner and a partner. Can you elaborate on that?
Use the terms interchangeably. There's not really a difference.
Okay, thank you. Can you describe the name of the person that you testified was a guardian home last time in the meeting on 11/15? The name was given as Melissa Rothby or Rothby. It was Valerie who reported that, but that name doesn't seem to match.
You can't find her anywhere, huh? No, we're not going to disclose any more information about people that we do business with in an open forum. We will give the trustee anything she requests from us.
Do you post information about your clients and partners in guardian homes on social media?
We used to. We don't anymore because of people.
Okay, but so today, none?
Not today.
When was the last time that you posted information about those guardians, partners, or co-owners?
I don't know.
Is Shabala Rodriguez a co-owner?
Yes.
And is there a pinned post on either Bulldogs By The Sea Facebook page or Valerie Jenvey's personal profile page describing Maya of Seafoam as being stolen by Shabala Rodriguez?
Probably, yes.
She stole the whole litter. Not just Maya.
Can you describe the ownership of Maya of Seafoam?
The co-own.
She was sold, a 50% ownership was sold with an obligation to provide 50% ownership of 2 litters.
And did you receive money from Ms. Rodriguez?
No.
We received a purchase for the original 50%, but there was to be, the litter was supposed to be shared, and we received no money from the litter, the 1 litter that was produced with that dog.
Okay, so for the purchase that you received, how much was that?
$5,000.
I would have to look at my records.
I think it's $5,000.
Is that a typical co-own price?
It can be all.
It's based on the fair value, fair market value of the dog. 50% of that value. That's how that's determined.
Okay, so then the value of Maya Seafoam at the time of purchase would be $10,000. Is that correct?
Mm-hmm.
Yes.
And what year was Maya Seafoam sold?
I would have to look 2021 or 2022.
And is Shabala Rodriguez considered one of the named people that you're considering litigation?
We considered litigation, but there's no chance of collecting, so we haven't pursued it.
Well,
she doesn't have any assets, so she...
Okay, but just because you're hoping to collect, as the trustee explained, doesn't mean that you can't disclose this. So is it fair to say...
We have not filed any litigation against her, nor do we intend to, because we don't have any belief that we'll be able to collect. Our attorney said, I can win this case easily, but you're not going to get anything back, so what's the point?
Okay, so the value of the damages for this possible litigation would be at least $5,000 for the money that you did not receive from her, as well as a litter, 2 litters, is that correct?
Asked and answered.
Well, no, can you repeat that, please?
Mm-hmm. Asked and answered.
Oh, okay, trustee, it's my understanding that this meeting is recorded, correct?
Yes, and if you'd like an official copy of today's meeting, you can contact the San Jose United States Trustee's office and they can provide you with an official copy.
Okay, so I'm still not clear what the missing component of this co-ownership is, but it's my understanding that they are due 2 litters from Maya Seafoam. Is that correct?
That was the original agreement, but Shabala Rodriguez stole a dog and stole a litter. What more can I say? She subscribed to the Heather McPherson How to Get a Free Dog Out of Valerie Jenvey because you accuse her of wrongdoing. She has stolen a dog and a litter of puppies from us. She is the one in the wrong. I don't know what why you're persisting on this with us. We're not going to get any money from the woman.
Okay, so can you...
So how do you consider it an asset? How can you consider it an asset?
Can you repeat the Heather McPherson subscription? What is that?
School of How to Get a Free Dog from Valerie Jenvey.
Okay, Ms. McPherson.
All the people in this call have done that.
All right. These are not appropriate questions or comments for this meeting. Ms. McPherson, you're just about out of time. You've got time for one more question.
Okay, let's see. This goes back to the medical expenses. Is there a reimbursement plan from your employer that gives you an account? I can't remember what the name of those are called, but it's basically you are reimbursed for portions of medical plans, and those are usually reported on tax returns.
I do not have that plan. I have medical, dental, and eye coverage through my employer. I do not have a whatever that plan's called.
Okay, all right. I think
those are typically...
That's all the time we have. So I'm going to go ahead and thank everyone for appearing today. I am going to conclude this meeting, and the case has already gone to an initial confirmation hearing, so it is off the court's list for confirmation. And once all of the objection points are resolved, then we can put the case on a calendar to get the case confirmed. But in the meantime, it's on a list of unconfirmed cases. And I will urge the debtors to please work diligently with Mr. Gunther to get the objection points resolved so that we can move this case toward confirmation at the earliest possible date. Okay? Thank everyone. Hang on one second. Before you hang up.
We didn't ask the second set last meeting.
Oh, I do have one more set of questions to ask. I'm sorry. Are the debtors still there?
Yeah.
Okay.
Yes.
So, did you each list all of your creditors in this paperwork?
Creditors?
Everyone that you owe money.
I think so.
To the best, a lot of the information came off of our credit reports, so to the best of our knowledge, yes.
Did you list everything you own, all of your assets?
Yes.
Ms. Jenvey?
Yes.
Have you transferred assets to anyone in the last 2 years outside of the ordinary course of your business?
No.
No.
Did you review the petition, schedules, and statements before you signed them?
Yes.
Yes.
And did you sign the paperwork yourselves?
Yes.
Yes.
And is the information in the petition, schedules, and statements true and correct?
Yes.
Yes.
And are there any other creditors on the line for the Jenvey matter? Any other creditors? All right, this matter is concluded. Thank you for appearing. You can go ahead and disconnect.
Devin Durham Burke, trustee in the above matter, objects to the confirmation of this plan for the following reasons. Was. The trustee is unable to determine if the plan is in compliance with USC, Prior 25, A. 5. The debtors have listed Chase Auto Finance for the 2023 Toyota RAV4 in Section 5 as a Class 2 creditor. However, pursuant to the proof of claim filed September 5, 2023, it appears the debt was incurred within 910 days prior to the petition file date. Based on this information, said creditor must be moved from Section 5 as a Class 2 creditor to Section 5 as a Class 5 creditor. 2. The plan is not feasible pursuant to 11 U.S.C. Paragraph 25A 6 because the debtors are proposing to pay an estimated total of $138,500. This is not enough money to pay all scheduled and/or filed secured, priority, administrative, and unsecured claims plus trustees' fees. As of the date of this objection, and based on the trustees' review of scheduled and filed claims, the debtors would need to pay $150,097.25. This amount can change daily because it is derived from many variables including the amount stated on filed claims, changing treatment of claims in amended plans, objections to claims, additional attorney's fees, and changing trustees' fees. The actual amount of money needed to complete the plan cannot be determined until after the plan is confirmed and all claims are filed and allowed. The trustee is providing the above number to assist the debtor in understanding why the plan is not feasible at this time. The number does not represent an actual payoff for the case and cannot be relied upon for any purpose other than to demonstrate lack of feasibility. Note: the trustee is in receipt of a proof of claim filed by Internal Revenue Service for priority debt totaling $20,100.55. 3. The debtors are not pledging all of their projected disposable income to pay unsecured creditors as required by 11 U.S.C. Paragraph 325b, 1b. The trustee is in receipt of a post-petition pay advice for Mr. Jenvey, dated August 18, 2023, which shows his income has increased from $12,023.84 as listed on the official form 122C1 to $16,187.87 per month. An amended official form 122C1 and 122C2 must file to provide for the increased income, pursuant to the holding in Hamilton v. Lanning 560 U.S. 505, 130 S.C.T. and 2464, 177 L. Edern 2D23, 2010. 4. The trustee is unable to determine whether the plan complies with 11 U.S.C. Paragraph 1325b, 1b. The trustee is in receipt of a post-petition pay advice for Mr. Jenvey, dated August 18, 2023, which shows his income has increased from $12,823.84 as listed on the Schedule I to $16,887.87 per month. Because of the significant increase in Mr. Jenvey's income, an amended Schedule I must be filed to be consistent with his current income moving forward. 5. The trustee requests that the debtors file a declaration that provides the terms of the TSP loan and the date of maturity. Until the debtors provide the requested information, the trustee is unable to perform her duties under 11 U.S.C. Par 302b, 1, incorporating 11 U.S.C. Par 74a4, and is unable to recommend confirmation. 6. The debtor has not complied with 11 U.S.C. Paragraph 521e, 2, a, I, and b, as the debtors have not provided the trustee with a copy of their 2022 federal and state income tax returns and W-2s. 7. The debtors failed to provide copies of income tax returns prior to the 11 U.S.C. Paragraph 341 Meeting of Creditors. See separate objection point, so that the trustee can verify that the copies that the debtors will provide are true and correct copies of the returns that were provided to the taxing agencies. The trustee requests that the returns provided to the trustee be attached to a declaration signed by the debtors, stating under penalty of perjury that the returns being provided are true and correct copies of the returns that the debtor submitted to the taxing authorities. 8. In order to assist the trustee in determining whether the disposable income test in 11 U.S.C. 325b, 1b, and or the feasibility test in 11 U.S.C. Bar 1325a, 6 is met, the trustee requests that the debtors provide her with a copy of each federal and state income tax return and W-2 form required under applicable law with respect to each tax year of the debtor's ending while the case is pending confirmation. The tax return shall be provided to her at the same time it is filed with the taxing authority. 9. The debtors are not in compliance with 11 U.S.C. Paragraph 1308a. The trustee is in receipt of proofs of claims filed by the Internal Revenue Service and Franchise Tax Board, which states the debtors have not filed their tax returns for 2017, 2018, 2019, and 2020. Before the trustee can recommend confirmation of the debtor's plan, all missing tax returns must be prepared and filed with the appropriate taxing authorities. Once prepared, the trustee requests verification that the returns have been filed with the appropriate taxing authority. 10. The trustee is unable to determine whether the plan complies with 11 U.S.C. FAR 325B, 1b. The debtors testified at the first meeting of creditors held on November 15, 2023, that they are now in partnerships for breeding French bulldogs. The trustee requests debtors file amended Schedules I and J to show their anticipated average gross monthly income from their dog breeding partnerships and their monthly business expenses associated with the dog breeding partnerships going forward. 11. The trustee is unable to determine whether the plan complies with 11 U.S.C. paragraph 325B, 1b, and 11 U.S.C. paragraph 325A, 4. The debtors testified at the first meeting of creditors held on November 15, 2023, that they have sold six of the 8 puppies that they listed under Article 13 of Schedule AB as 8 French bulldog puppies, $2,000 each. The trustee requests copies of each of the sales contracts for all 6 puppies, including the 7th and 8th puppy, if recently sold, from this litters in order to verify the value of these puppies at the time the case was filed and the actual income received from the sale of each puppy. 12. The trustee is unable to determine whether the plan complies with 11 U.S.C. paragraph 325A, 4. The debtors testified at the first meeting of creditors that they had a bank account with d.b.a. Federal Credit Union at the time of filing the Chapter 13 bankruptcy. The debtors further testified that the account was closed post-filing. The debtors must file an amended Schedule AB to list the bank account with d.b.a. Federal Credit Union and disclose the amount in the account at the time the Chapter 13 bankruptcy was filed. The debtors must provide the trustee with a copy of the bank statement from d.b.a. Federal Credit Union for the month of August 2023. 13. In order to verify that the plan complies with 11 U.S.C. paragraph 325B, 1b, the trustee requests copies of the debtors' bank statements from their Wells Fargo business checking account for the months of January 2023, February 2023, March 2023, April 2023, May 2023, June 2023, July 2023, August 2023, September 2023, and October 2023. 14. The trustee is unable to determine whether the plan complies with 11 U.S.C. paragraph 325A, 4. The trustee requests a copy of the statement for the mutual funds account, with Morgan Stanley listed online Darmer 18 of Schedule AB for the month of August 2023. 15. The trustee is unable to determine whether the plan is compliance with 11 U.S.C. paragraph 325B, 1b. The trustee requests copies of all transaction statements from Zelle and Venmo accounts utilized by the debtors from January 2023 to the end of October 2023. The transactions must include the amounts and description of receipts. The debtors must be able to identify what transactions were personal versus business. The debtors must provide the trustee with a declaration signed under penalty of perjury, which explains the transactions. 16. The trustee is unable to determine whether the plan complies with 11 U.S.C. paragraph 325A, 4. The debtors testified at the first meeting creditors held on November 15, 2023, that they currently have four pending countersuits against various parties that have not been listed on Schedule AB, JR 34. The countersuits must be listed as potential assets of the debtors, along with the anticipated values of each countersuit. 17. The trustee is unable to determine whether the plan complies with 11 U.S.C. 325B, 1b. Pursuant to testimony given by debtors at the first meeting of creditors, held on November 15, 2023, the debtors rented a room in their house in 2021 and 2022. No rental income is listed on the debtors' 2021 income tax return or on Official Form 107, Statement of Financial Affairs for Individuals Filing for Bankruptcy. The trustee requests that the debtors file a declaration under penalty of perjury that provides the following information. 1. the gross amount of rental income the debtors received for calendar year 2021, 2022, and 2023, and 2, the last month and year that the room was rented. The trustee requests that the debtors attach a copy of the rental agreement for the periods the room was rented. 18. The trustee is unable to determine whether the liquidation test met pursuant to 11 U.S.C. 325A 4 because of the unknown value of the automobile accident claim lawsuit listed on line 33 of Schedule AB. In order to assist the trustee in monitoring the value of this automobile accident claim NART lawsuit, the trustee requests that the debtors add a non-standard provision to Section 10 of the plan to state the following. Each May 1st, during the pendency of the case, beginning with May 1st, 2024, the debtors shall provide the trustee with either a declaration by Ms. Jenvey under penalty of perjury or a letter from the attorney representing her for the car accident claim lawsuit listed on line number 33 of Schedule AB, which provides a status report on the automobile accident claim lawsuit. The declaration or letter shall describe the status of any litigation, settlement, or stipulation concerning the automobile accident claim lawsuit. It shall also state whether the debtor has received or will receive any proceeds on the automobile accident claim lawsuit, the date of receipt of proceeds, and the amount or projected amount of proceeds received or to be received. Once the automobile accident claim lawsuit has been resolved, the debtor shall provide the trustee with a detailed accounting of the resolution, including, but not limited to, total settlement and a breakdown by 1. Personal injury, 2. Property damage, 3. Lost earnings, 4. Punitive damages, and 5. Pain and suffering. The debtor must also state the total attorney fees paid in this case. 19. The trustee is unable to determine whether the plan complies with 11 U.S.C. 1325A. 4. The debtors have listed a total of 15 French Bulldogs puppies as assets on Schedule AB. The debtors testified that the value of a French Bulldog puppy is determined by the gender, DNA, and color. The trustee requests the debtors provide a detailed breakdown of each dog puppy listed on number 13 of Schedule AB. The debtors must provide the trustee with the name of each dog puppy, a description of the dog puppy that includes its gender, color, age, and any other factors that pertain to the individual dog, along with the fair market value of each dog and how the fair market value was determined. If the debtors obtained or acquired any other dogs after August 11, 2023, then the debtors must provide the trustee with a list of those dogs' puppies as well, including the name of the dog puppy, gender, color, age, and description of the dog puppy, along with the value associated with the individual dog puppy and how the value was determined. 20. The debtors testified that they currently have 3 French Bulldogs that are expecting litters in November and December. The puppies will not be able to be sold until they are approximately 7 to 8 weeks old. In order to ensure the plan complies with 11 U.S.C. Paragraph 325B, E1, B, the trustee requests debtors file an amended plan to add a non-standard provision under Section 10, which requires the debtors to provide periodic declarations regarding the litters of puppies that they have any interest in during the pendency of the case. The language should state the following. Each January 30th and July 30th during the pendency of the case, beginning with January 30, 2024, the debtors shall provide the trustee with a declaration under penalty of perjury, which provides an accounting for each dog puppy sold. The declaration shall describe gender and color of each dog puppy and have a copy of each sales contract associated with the dog puppy attached. It shall also state the amount the debtors received from the sale of each dog puppy and shall also disclose whether there are any dogs currently pregnant and dates of the expected litters. The debtor must also provide a breakdown of any expenses paid with proof of the expenses attached for the puppies prior to the sale. 21. The trustee is unable to determine whether the plan complies with 11 U.S.C. Paragraph 1325A, 4. The debtors testified at the first meeting of creditors held on November 15, 2023, that they have an ownership interest in 3 dogs and their puppies that are due in November 2023 and December 2023. The debtors have failed to disclose this information under number 37 of Schedule AB, 22. In order to perform her duties under 11 U.S.C. Par 1302C, incorporating duties under 11 U.S.C. Par 1106A. 3. The trustee has determined that a business examination is required in this matter. The business examination documents have not been provided, and the trustee requests additional time to review the petition, plan, schedules, and business examination documents concurrently. 23. The trustee is unable to determine whether the plan complies with 11 U.S.C. paragraph 13925A4. The debtors testified at the continued first meeting of creditors held on November 29, 2023, that they have several defamations of character claims and slander claims against various individuals' entities. The trustee requests debtors file an amended Schedule A-B to list these defamations of character claims and slander claims separately, along with an explanation of what type of claim they are for and who they are against. 24. In order to determine whether the plan complies with 11 U.S.C. CRA 325A.4, the trustee requests debtors file an amended plan to add a non-standard provision under Section 10, which requires the debtors to provide semi-annual declarations to provide status reports as to the various defamation and slander lawsuits the debtors have filed against various parties. The non-standard provision shall state that beginning July 1, 2024, and then each July 1 and January 1 thereafter, the debtors shall file a declaration with the court, signed under penalty of perjury, and shall provide the current status of each of the defamation and slander lawsuits the debtors have against each party, and describe the whether or not they have collected any money as a result of any litigation, the status of any pending litigation, and whether or not they are going to continue to pursue the various lawsuits. 25. The trustee is unable to determine whether the plan complies with 11 U.S.C. Paragraph 1325A. 4. The debtors testified at the continued first meeting of creditors held on November 29, 2023, that they have a judgment against a person named Mindy Hazel Sanchez in the amount of $12,000. The debtors have failed to list this asset on Schedule A-B. 26. The trustee is unable to determine whether the plan complies with 11 U.S.C. CRA 1325A. Prior. The debtors testified at the continued first meeting of creditors held on November 29, 2023, that they are still trying to determine whether they intend to pursue their countersuits against Rebecca Lomelli and crowd pleaser Frenchies. The trustee requests debtors file a declaration with the court, signed under penalty of perjury, which states whether the debtors intend to pursue the two small claims court cases they have filed against Rebecca, Lomelli, and crowd pleaser Frenchies in Monterey County. Dated December 11, 2023. Signed Devin Durham Burke, Chapter 13. Trustee. Factual background. The Chapter 13 petition was filed on August 11, 2023. Docket number 1-2. Devin Durham Burke is the duly appointed Chapter 13 trustee in this matter. The trustee has had an objection to confirmation, pending since September 21, 2023. Docket number 22. The unresolved points raised in the trustee's objection, and any amendments thereto, prevent the trustee from recommending confirmation of the Chapter 13 plan. Moreover, to the extent that another party has filed an objection to confirmation that remains unresolved and/or the debtors have not made plan payments, including amounts coming due prior to any hearing on this motion, these serve as additional and independent impediments to confirmation. The failure of the debtors to act promptly to resolve all impediments to confirmation has caused unreasonable delay that is prejudicial to creditors because creditors are not receiving payments and/or cannot exercise their state court remedies to collect their debts, while the debtors enjoy the benefit of bankruptcy protection in this case. On February 8, 2024, case number 23-50878 was dismissed, and the case was closed May 8, 2024. Since then, the District Attorney of Monterey County has filed a civil case against both Kenneth and Valerie Jenvey, filed civil case number 24CV00541, People of the State of California versus Ken Jenvey, et al., case type. Business tort, unfair. Bus Prac Unlimited, 07. This case is scheduled for hearing October 9, 2024, with a request for trial. Ms. Jenvey has filed separately for Chapter 7 bankruptcy on July 1, 2024, where it was dismissed for failure to provide documentation, and then again on July 31, 2024, making this her third petition for bankruptcy in less than 12 months. Her current case number 2451165 is scheduled for public hearing for the Meeting of Creditors, August 23, 2024, at which time she will be required, again, to testify under oath with penalty of perjury.